today, and I wrote about this on pjmedia.com. You can go there, find me, go to columnist, click on Megan Fox, you'll find all my stuff. Shocking lawsuit alleges Missouri family court judge unlawfully imprisoned, terrorized America's Got Talent stars. These are these two precious little children who were jailed by this judge.
That's insane.
In Missouri, the doorway to hell, by the way. If you were wondering where hell is, you can enter it through Missouri. Caden and Brooklyn Rockett were living an exciting and fun life before the family court got a hold of them and things took a dark turn. The Rockett children had a thriving career following in the footsteps of their father, Bart Rockett, a working magician and performer. They appeared on America's Got Talent and were stepping into acting when the family court nightmare began. The judge was so opposed to the children working in the entertainment industry, and he determined to give them to their mother in Utah, and he threw them in jail twice to make that happen. A lawsuit against Judge Eighmy filed on behalf of the children by their father describes the hell that they went through in Missouri courts. Wait, he left the bench, took off his robe, court was over, went out into the hallway, and escorted those children himself to the jail.
He needs a psych eval.
Oh, he needs to be in jail himself, and he's done it. He did it twice. So in December, Judge Douglas Harpool of the United States District Court ruled that the Rockett lawsuit will not be dismissed based on immunity. The allegations contained in the complaint are that the judge acted without jurisdiction and outside his judicial role when personally taking the children to jail, then subsequently ordering them picked up in Louisiana when there were no judicial proceedings pending that would allow for this judicial sanction. Whether plaintiff will be able to ultimately prevail is a question for another day. However, here, based on the allegations contained in the pleadings, plaintiff has stated a claim that judicial immunity may not apply, and certainly a claim that cannot be resolved by a motion to dismiss.
Nice.
The ruling by Harpool does a good job summarizing the allegations in the case, which we already went over. That happened in December. Well, of course, they appealed. Now, here's something I need you to understand. Who do you think, Stephanie? I'll give you a guess. Who is obligated to defend them?
Obligated?
Obligated.
No.
The Attorney General of the state.
Oh.
For free, on you, taxpayer paid.
Oh, that's terrible.
The Attorney General, you thought the Attorney General of the state was the people's lawyer? Think again. The Attorney General is the state's lawyer.
Okay. If the judge had been facing a judicial disabilities complaint, which, by the way, was he? Did they ever file a judicial disabilities complaint against him?
Oh, I'm sure that was filed and they throw it out. Everything in Missouri that gets filed. Wait,
okay.
No, I have an entire drawer full of these things. I have a whole thing. Like, wait, look. Do you see? This is just one of the binders that I have in my, look how thick this is. This is just one. This is just the St. Louis County victims. Every single one of these people in this binder, every single one put a professional complaint in about either judges or attorneys, and every single one got thrown right in the round bin. And they were told that they couldn't investigate it even. They were just, nope, you don't have a case.
Wow. So in Maryland,
and I have 2 drawers full of those.
Let me just understand real quick procedurally. This is on appeal on the question of the motion to dismiss. So there's been no trial on the merits yet. We're still fighting.
We're still fighting the motion to dismiss. They have appealed and appealed. I mean, this is all the way to the circuit court, Stephanie. The next step is the Supreme Court. Are they going to appeal to the Supreme Court?
You
know what you people need to do? You people need to get on the phone tomorrow. That's what we're going to do. We're going to get on the phone tomorrow. We're going to call the Attorney General's office in Missouri and tell them, stand down. Stand down. Let this family have their day in court.
I mean, really, it's at what point does it become a total abuse of taxpayers' money?
It's already an abuse of taxpayers' money, and it's an abuse of this family who have already been abused. What the children?
In fact, you know what? If the Court of Appeals, if the 8th Circuit says, no, the district court judge was right, he has no immunity for this, the case is not going to be dismissed on a motion to dismiss, let it proceed. At that point, the AG should step down and say, you're on your own, man. Get your own lawyer.
Get your own lawyer.
The courts have said you were not acting in your capacity, in your authority as a judge, and therefore you don't have a right to have me representing you. The people are paying for this, and we're going to stop. I mean,
I think Blurple Dragon's got it right. We're calling the AG tomorrow, and we're telling him, due process for the Rockett children now. That's enough. It's enough. Stop it.
It's terrible.
What do you mean, you people?
It is the question for immunity purposes is less about whether he exercised an authority lawfully given and more about whether what he did is something judges do.
Well, how frequently in Missouri or any other state that you're familiar with do judges take people to holding cells?
Children.
Wait, really,
I wish
seriously.
I could see the judge's face.
I know, me too. What kind of argument is it to say, well, this is really not about whether he had the authority to do it, but about do judges do it is really the argument.
So, and I think the dissent there argued this has never been done before. What the Supreme Court said is even if a petition is passed on only once, that doesn't vitiate immunity. What matters is whether it's a function normally performed by a judge. And judges do normally engage in what may be termed a seizure under the Fourth Amendment.
Judges do normally engage in kidnapping, so it's fine. So it's fine. So I mean, it doesn't really matter whether they have the authority. They regularly do it, and so precedent. That's my argument. This is literally this guy's argument. I want you to understand.
I still can't get over this Stump v. Sparkman idea that the Supreme Court said, if that guy is correct, that this is something judges do.
This is something judges do.
Judges routinely order that young women be sterilized against their will. What?
Now, let me just say, judges will protect their own, and they do not want to eliminate the power that they have to control the people in their courts. And even the Supreme Court members will absolutely rule with their brethren in the black robes every time, which is why the Supreme Court should not be the ultimate decider on what happens to judges. Because they are judges.
Authority.
They do it, but not this way. I think this judge had a little bit of black robe disease and thought his power was maybe a little bit more than it actually was. And usually when you do something like this in state court, I used to be a state court judge, you actually go through some procedures. You don't walk into a conference room, you don't throw two kids into jail, make them take off all their shoes, put them in a holding pen, and then when they come out, tell them they're going to go to foster care if they don't listen.
Wait.
Two answers.
That's the judge.
Judge Eighmy was presented with a situation where the children were not complying with an order that was entered for their welfare. And
it's not a motion for reconsideration. I mean, there was no hearing. It was the non-parties that were objecting to this. I mean, it doesn't look anything like a motion for reconsideration. I mean, that would be a judicial function. And there are, as Judge Strauss indicated, procedures that go with that. And an order would issue. Right? An order would issue.
It's a bad sign when the judge is hearing your argument say, it doesn't look anything like that, like what you just said.
Well, plus procedurally, that just doesn't work, because if the kids had supposedly filed some motion for reconsideration, due process would require that the judge give everybody involved an opportunity to respond. You don't just make a motion and then the judge says, oh, okay, yeah, or no, I don't like it. No, that's not how this works. We have due process rights here.
This is the authority he used to seize them, to quote unquote seize them, was his judicial authority. Mr. Rockett agrees to that in his brief. So they approach him as a judge. They ask him essentially, they debate about the validity of an order. They don't want to comply with it. And when they continue to refuse to comply with it, Judge Eighmy walks them down to the detention center and orders uniformed officers to take them into custody. That's very similar actually to Newman v. Indiana. The judge there, that was a seizure. They sued for temporary deprivation of liberty. The Seventh Circuit noted that, and it was a midnight hearing in the judge's chambers. And the judge, after the hearing passed, said, I'm not going to grant your motion, your extra hearing, and you need to stay in my chambers until the sheriffs are done picking up the child at your at your house.
Now, my understanding, though, and correct me if I'm wrong, is the judge walked out from chambers. He didn't have his robe on, and you're saying that the children actually approached him. I thought he approached the ensuing discussion that was happening in the courthouse lobby. Am I wrong about that?
I think that is correct, but the
You
engagement
lied.
with the children and the reason they followed him was because he was a judge. And so the authority
No, he just lied. He said that
He just lied.
the children approached the
approached
judge.
him.
And that's a lie. It's a damn lie.
process, and it's related. You brought up foster care, Judge Strauss. It's related to the authority of the Missouri Circuit judges to take children into custody when it would be in their welfare.
You know, I'm thinking that actually this doesn't fall under any government authority at all, which is an executive officer has to, an executive official, a police officer has to have at least probable cause or reasonable suspicion to stop and seize someone. He clearly didn't have arguable probable cause or arguable reasonable suspicion. So he wasn't using executive authority, and judicial authority ordinarily happens in a courtroom with, as Judge Kobus says, with some sort of process. So it doesn't appear that he's actually exercising judicial authority. And I don't think there's any legislative authority going on. So it seems to me like there was just no authority for what Judge Eimy did.
Well, we point out in Missouri law that he is allowed sua sponte to do contempt. He is allowed to.
There's no formal order.
No.
Well, he ordered the uniform officers to take him into jail.
But there was
Not
no
on the
order.
record.
He directed them to take certain, their shoes off and the bracelet off. Is that correct? I mean,
Well, yes, he escorted them, but then I would go to.
he ordered them. They were in custody. Don't you agree?
They were in the same way the plaintiffs were in custody in Newman. The judge used his.
My God, if I were these judges on this panel, I would be like, bailiff, take him into custody right now. Take the judge into custody right now and put him in the detainment center down and take his shoes and socks right now. I've heard enough.
Wait, and do a strip search.
And strip search him with a cavity search, sir. And then, and you know what, Judge Eimy? If you think that's a problem because you didn't get your due process, I guess I'll see you in court for the next 5 years. But that's what we're gonna do. We're gonna take him in custody right now. Let's go. That's me on the bench, by the way. If I ever get appointed as a judge, that's what I will do.
So much.